This podcast contains content generated or significantly edited using artificial intelligence tools. All information is provided for general informational purposes only and reflects knowledge available at the time of publication. It does not constitute financial, investment, or legal advice. We recommend that listeners verify the information independently and consult with qualified professionals for personalized advice. Welcome to the Luxembourg Fundcast.
Okay, let's dive right in. Today, we're taking your source material and really digging deep to pull out the key insights. Our focus is this fascinating document that maps out the world of legal opinions in Luxembourg, specifically for, financial professionals.
Yeah, and it's interesting because it's not just some dry legal text, is it? The source presents it as an excerpt from the Luxembourg Fundcast itself. So that gives us a unique window into how these, frankly, complex legal ideas are explained to that specific audience, people in cross-border finance.
Exactly. Think of it like getting a peek behind the curtain, a look at a very specific but incredibly important corner of international finance. Our mission here is to unpack this source, figure out what makes a Luxembourg legal opinion tick, and why it's such a big deal.
Right. We're going to look at its sort of fundamental purpose, the bedrock laws it leans on, and then get into the specifics, what confirmations it actually provides, clause by clause. We'll also touch on the practical side, how you actually get one, and importantly, how this whole field is evolving, stuff like MACAR.
Crucial information, really, for anyone navigating transactions that involve Luxembourg entities.
So the source kicks off with an executive summary. It defines a legal opinion pretty clearly, a formal written document from a law firm confirming legal matters. But the key thing it stresses is that it's a reasoned professional judgment. It's not a guarantee, not insurance.
Right. And its main job, identifying and mitigating legal risks. Often it acts as what they call a condition precedent, meaning the deal probably won't close without it.
Precisely. It's a hurdle you have to clear. The source then lays out its own structure. Foundations, anatomy, that's the clause-by-clause bit the life cycle, so negotiation to delivery, and then future trends.
Okay, so let's start with those foundations. Part 1, the fundamental why behind these opinions. Why are they actually necessary?
Well, the source tells us they give a law firm's professional judgment on specific legal points that are critical for the recipient's commercial decision. Think about a big loan or an acquisition involving a Luxembourg company. The opinion gives comfort on the legal side of things. It's, as you said, often a key condition precedent before money changes hands or ownership transfers.
And who are the main players involved in this? Who gives them, who gets them?
The source breaks it down into three main parties. First, you've got the opinion giver. That's the law firm issuing the opinion. They usually represent the borrower or the seller or maybe the issuer in a capital markets deal.
Okay.
Then there's the opinion recipient. That's the party asking for it, and relying on it could be the lender, the buyer, the underwriters.
Makes sense.
And finally, the client. That's the party the opinion giver is acting for. Now, the giver has a duty to their client, obviously, but crucially, they also owe a duty of care to the recipient who's relying on their work.
Right. That duty of care is important. And when do these opinions typically land in a transaction timeline?
Almost always right at the point the deal becomes legally binding. The source mentions like the closing of a financing deal, just as funds are dispersed, or in an M&A context, right when ownership officially transfers. It's that moment of peak legal exposure for the recipient.
Okay, now this is where I find it gets really interesting, the bedrock legislation. What specific Luxembourg laws give these opinions their authority, their strength?
Yes. The source highlights three absolute pillars here. First up is the law of August 10th, 1915 on commercial companies. Everyone just calls it the company law.
The company law, got it.
This is, it's the foundation stone for corporate law in Luxembourg. It governs basically everything about companies. It defines the main types you'll encounter. The Société Anonyme, or SA, the Société à Responsabilité Limitée, or SARL, and increasingly common, the Société en Commandite Spéciale, or SCSP. That SCSP stands for Special Limited Partnership. You see it a lot in fund structures.
Right, the SCSP.
The law establishes that these entities have distinct legal personality. It lays out the formalities for setting them up, like needing a notarial deed for an SA or SARL, that's under Article 104. It also requires them to publish certain info in the electronic gazette, the Recueil électronique de sociétés et associations, known as RESA. And crucially for opinions, the company law defines the powers of the company's governing bodies, the organs, like directors or managers, and how they can legally bind the company when dealing with others. That's covered in Article 116. So basically, every confirmation information you see in an opinion about the company's status or its ability to do the deal, it links back to this law.
Okay, that makes total sense. Foundational. What's the second pillar?
The second one is the Luxembourg Civil Code.
Civil code, right.
As the source notes, Luxembourg is a civil law country, heavily influenced by the Napoleonic tradition. And for legal opinions, there's one article that really stands out. Article 1134. This embodies that core principle, pacta sunt servanda. Basically, contracts are binding.
Pacta sunt servanda. Agreements must be kept. The source even quotes the French, doesn't it? Les conventions légalement formées tiennent lieu de loi à ceux qui les ont faites.
Exactly. Legally formed agreements serve as law for those who have made them. This is the absolute bedrock for what we call the enforceability opinion. It's the legal basis for saying a contract is valid and can be enforced in court.
But is that enforceability absolute? I mean, surely there are exceptions or limits.
That's a critical point the source really hammers home. No, it's not absolute. An enforceability opinion based on the civil code always comes with qualifications. Things like potential limits from judicial interpretation, overarching principles like public policy, the duty to act in good faith, even the concept of abuse of right.
And didn't the source mention something about potential reforms?
Yes, ongoing discussions about potentially reforming the law of obligations, maybe introducing something like a hardship doctrine or improvision, which could allow courts to adjust contracts if circumstances dramatically change. But for now, Article 1134 is key with those inherent limits.
Fascinating. Binding, but with caveats. Okay, what's pillar number 3?
This one's huge for finance deals.
Yeah.
The Law of 5, August 2005 on financial collateral arrangements, usually just called the Financial Collateral Law.
Ah, the 2005 law. Heard a lot about that one.
It's absolutely central to Luxembourg's financial sector. It brought the 2002 EU directive into Luxembourg law and created this very secure, very robust regime for security interests, like pledges over financial assets. We're talking cash, securities, certain claims.
What makes it so robust? What's the magic ingredient?
Well, the source points to a few things. Simplified ways to create and perfect the security. Perfection is just the legal step needed to make the security effective against everyone else, like other creditors or an insolvency receiver.
Okay, so how do you perfect under this law?
Often it's just a written agreement plus some form of dispossession or control, like crediting pledged securities to a special pledge account. But the really big deal, as the source highlights, is that it's a loi de police, an overriding mandatory rule. This means it trumps most general laws, including big chunks of standard insolvency law. It's deliberately designed to be, well, bankruptcy-proof.
Bankruptcy-proof. So a secured creditor can actually enforce their security even if the borrower goes bust.
Pretty much, that's the goal. Secured creditors under this law can often enforce their rights, maybe take ownership of the collateral, or sell it privately straight away if there's a default, without getting stuck in long insolvency proceedings. So opinions given under this law offer a very high degree of certainty.
So it sounds like an opinion focused specifically on security under the 2005 law is maybe stronger or carries more weight than a general enforceability opinion under the civil code?
That's exactly what the source suggests. Because the 2005 law is so specific, so detailed, and designed to override other rules, opinions covering security under it can usually be given with, let's say, more confidence and fewer general qualifications compared to one just relying on the broader civil code principles.
So this Luxembourg legal opinion practice, it's a unique mix then. The format might look familiar from international deals, maybe Anglo-American style.
Right.
But the actual legal substance, the comfort it gives, is all tied back to these specific Luxembourg civil laws.
That's a great summary. The source confirms that international parties get a document that feels familiar, but its strength comes directly from Luxembourg's own legal code. And what's also interesting, the source points out that there aren't detailed official guidelines from the Luxembourg bar on how to write these opinions. Not like in the U.S., where you have things like the Tri-Bar Opinion Committee reports.
So without official guidelines, how does everyone know what's standard practice? How is it standardized?
Good question. The source says it really comes down to established, market-driven customary practice. It's set by the leading law firms who are active day in, day out in the financial center. Their reputation, their consistency, that's what sets the market standard.
Right, reputation and customary practice. Okay, let's shift gears then to part 2. The anatomy. What do these opinions actually say? Clause by clause.
Yeah, the source has a helpful breakdown linking common clauses to their purpose and the main law behind them. We can kind of group them.
First up, The corporate confirmations, the status opinions, right, about the company itself.
Exactly. These focus on the legal health of the Luxembourg entity involved. The first big one is usually due incorporation and existence.
Due incorporation and existence, what's that confirm?
It confirms the company was set up properly according to the company law, so for an SA or SIRL. Checking that required notarial deed from Article 102 exists, and, crucially, that it's still legally in existence today.
And how do they check that?
Verification typically involves looking at the company's up-to-date Articles of Association and getting a fresh excerpt from the Luxembourg Business Register, the LBR. That's the official registry confirming existence, address, registered officers, etc.
LBR. Got it. Then there's corporate power, capacité, and authority, pouvoir. What's the difference there? Seems subtle.
It is subtle but important. The source explains it well. Capacité, or corporate power, is about the company's fundamental ability to even enter into this type of transaction. Does it fit within its corporate purpose, its objet social as defined in its articles?
Okay, what it can do?
Right, whereas pouvoir, or authority, is about who has the power to act for the company in the specific deal. Have the right people been properly authorized to sign the documents?
Ah, okay. Who can do it?
Exactly. The company law, especially around corporate bodies, organs, and representation like Article 116, dictates how this works. So the opinion confirms the correct body. Maybe the board of directors approved the deal and specifically authorized the individuals who signed. This is usually checked by reviewing board minutes.
Got it. Power is what, authority is who. Makes sense. Okay, moving on from the company itself to the deal documents, the transactional confirmations.
Yes, the deal opinions, starting with a relatively simple one, due execution.
Due execution just means it was signed properly.
Pretty much. Confirms the documents were physically signed by the people who were confirmed as having the authority to sign. Straightforward.
And then, the big one for the main agreement, valid and binding obligations, the enforceability opinion.
This is usually the heart of it for the main contract. It states the agreement is legal, valid, binding on the company, and enforceable against it according to its terms. And as we discussed, the legal basis is Article 134 of the Civil Code Pactus Sunt Servanda.
But we already established it's not absolute. Those qualifications are key.
Absolutely critical. The source stresses this. The enforceability opinion is always subject to qualifications. The big ones usually relate to bankruptcy or insolvency laws. The opinion acknowledges that if the company goes bust, general creditor protection laws might override some contract terms.
Makes sense. What else?
Then there are qualifications for equitable principles. This recognizes that courts have some discretion. They might not order specific performance, they might award damages instead, for instance.
Right.
And limitations related to public policy order public. Courts won't enforce anything that goes against fundamental Luxembourg public policy. Plus, the opinion usually carves out specialized areas, tax, environmental law, competition law, unless they were specifically agreed to be covered.
Okay. Now, for secure deals, there's another crucial one, validity of security interests.
Yes, vital in lending. This confirms that the security documents say a pledge agreement creates a legally valid and enforceable security interest over the specified assets, and importantly, that the security interest has been properly perfected.
And this is where that 2005 financial collateral law really comes into its own again.
Exactly. The source emphasizes how this law provides a clear path for creating and perfecting security over financial assets. Like we mentioned, crediting securities to a pledge account is a common way to achieve perfection. And the law explicitly makes the security bankruptcy-proof against many insolvency challenges like clawback risks.
So the opinion confirms you dotted the I's and crossed the T's under that powerful 2005 law to create that strong security.
Precisely. And because the law is so robust, the opinion confirming a valid and perfected security interest under it can be given with, as we said, a high degree of confidence.
What about regulatory and compliance type opinions?
There's usually a no violation of law or charter opinion. This confirms that signing and performing the deal documents won't make the company breach its own articles of association or relevant Luxembourg laws. Though, as the source notes, this is often limited to general corporate law and doesn't usually cover every single regulation out there unless specified.
Okay. Now, the source highlights a really interesting new development here, the MyCar legal opinion. This sounds different.
It is a really significant shift. MyCar, that's the Markets in Crypto Assets regulation, actually introduces a mandatory legal opinion requirement in certain situations.
Mandatory. So not just something the parties agree on. How does that change the opinion's role?
Fundamentally, it shifts it from being mainly a private risk management tool between deal parties to becoming a public regulatory compliance instrument. The source uses the example of someone wanting to issue an asset reference token, or ART. That's a type of crypto asset designed to maintain a stable value by referencing other assets.
An RT, okay. And who makes this mandatory?
The financial regulator in Luxembourg, the Commission de Surveillance du Secteur Financier, the CSSF.
Right.
The source mentions CSSF Circular 25890, which puts EU guidelines into practice. It requires this specific legal opinion to be included in the authorization file submitted to the CSSF when applying to issue an RT.
And what exactly does this MICAR opinion need to state?
It has to confirm two key things. First, that the RT doesn't fit into any crypto asset categories that are excluded from MICAR. And second, that it doesn't qualify as an e-money token, or EMT. An EMT is different. It's linked to just one official currency, like a digital euro.
So the opinion is basically helping the regulator classify the token correctly.
That's exactly it. The source frames it as the opinion acting as a regulatory gatekeeper. It forces issuers to get a formal legal analysis done up front, helping the CSSF categorize the token properly and preventing people from trying to game the system by mislabeling their crypto asset.
And the audience isn't the lender anymore, it's the CSSF, the regulator.
Precisely. And the content isn't negotiated, it's prescribed by the regulation. This puts a lot more responsibility on the law firm. They're acting almost as a checkpoint for the regulator.
Very interesting dynamic. Okay, let's move to part 3, the practical life cycle. We understand the law, the clauses.
Yeah.
But how does this actually work in practice? The source calls the negotiation part the opinion dance.
Yes, it can feel like that. It involves a bit of back and forth. It usually starts quite early in the deal process.
Yeah.
Typically, the lawyer for the opinion recipient, the bank or buyer wanting the comfort, sends over their first draft. Often it's their standard template, and it might be, well, a bit ambitious initially.
Too broad.
Often, yes. So the opinion giver, the firm, acting for the borrower or seller, then reviews it carefully and marks it up. They need to tailor the confirmations to what they can realistically and responsibly give based on Luxembourg law and the facts. They'll insert necessary assumptions about facts they won't verify independently and add the qualifications we talked about, those legal limitations like bankruptcy or public policy.
So it's a negotiation.
Definitely. It's a process to arrive at a final opinion that gives the recipient the necessary assurance, but is also something the giver can stand behind. The source stresses that this requires good faith and understanding of market practice on both sides, so it doesn't hold up the deal unnecessarily.
Let's dig into that fine print a bit more. Assumptions and qualifications. The source says they're not just boilerplate text.
Absolutely not. They're crucial. Assumptions are the factual foundations the legal reasoning rests on. To keep things practical, the law firm assumes certain things are true without checking every single detail themselves. Common ones listed in the source include assuming signatures are genuine, that original documents are authentic, and copies are true copies.
Okay.
Also assuming that the other parties in the deal have the legal capacity and power to act under their governing laws, and assuming the transaction documents are valid under those other laws too, plus relying on the accuracy and completeness of info from the client and public records, like the LBR.
Right, and qualifications. They limit the legal confirmations.
Exactly. They reflect the boundaries of the law itself. Standard ones the source points out are: the bankruptcy qualification enforceability is subject to insolvency laws.
We covered that.
Qualifications related to equitable principles, the court's discretion on remedies. Exclusions for specialized laws, tax, environment, competition, unless specifically included. And critically, the opinion is based on Luxembourg law as it stands on the date it's issued. The firm has no obligation to update it if the law changes tomorrow.
That makes sense. What about the documents needed for due diligence? What does the law firm actually look at? The source mentions a checklist.
Yeah, they need to build a solid factual basis. Key documents include corporate constitutional docs, like the coordinated articles of association, statuts coordonnés, to check the company's purpose and governance. A recent LBR excerpt, extrait du registre de commerce et des sociétés, for existence, address, officers, and usually an RBE excerpt, that's the Register of Beneficial Owners, for anti-money laundering checks.
Okay, constitutional stuff. What else?
Transactional authorizations. So the board or manager resolutions approving the specific deal and authorizing the signatories, maybe shareholder resolutions too, if it's a really major transaction requiring that level of approval under the company law.
Right, the proof of authority.
Then, of course, the final executed transaction documents themselves, the actual contracts being opined on, and often various Searches and certificates, maybe litigation search results if they're giving a no litigation confirmation, and a certificat de non-inscription d'une décision judiciaire, that's a certificate confirming no registered bankruptcy judgments against the company.
Seems like a thorough process. Practically speaking, what about timelines and costs? How long does it take, and what drives the price?
Well, the opinion work runs alongside the main deal negotiation. Timeline-wise, it can vary a lot. Simple case, maybe 1 or 2 weeks. Complex deal with multiple companies or agreements could be significantly longer. The key thing is it has to be ready right at closing.
And cost. Is it not cheap, I imagine?
It's typically part of the overall legal bill for the transaction. The source mentions it's often hourly, but capped or fixed fees are also common now. What drives the cost? Several things. Complexity is a big one, more entities, more contracts, maybe other jurisdictions involved. The amount of negotiation needed on the opinion itself, if there's a lot of back and forth, that takes time and increases cost.
Okay.
The inherent risk and liability the law firm takes on is also a factor. Higher value transactions generally mean higher risk, which can influence the fee, and naturally urgency. If you need it done yesterday, that usually costs more.
And the source really emphasizes that this cost reflects the intensive work involved, doesn't it?
Okay.
The diligence, the legal analysis, the senior lawyer time. It's a high-stakes document.
Absolutely. It's not just filling in a template. It's expert judgment based on careful work, carrying significant professional responsibility.
Okay, let's wrap things up by looking at part 4, market context and the future. How does this practice fit into the wider Luxembourg market, and where is it heading?
The source touches on the importance of customary practice. As we noted, without formal bar guidelines, the standards are really set by the established, consistent practices of the major law firms. It's this blend of meeting international expectations while staying true to Luxembourg law. A firm's reputation is paramount here.
And what about emerging trends? What's changing?
The source highlights a few key trends. First, that rise of regulatory-driven opinions. My Car is the big example right now, changing the opinion from a private tool to a public requirement. The source speculates this might happen in other areas too, maybe ESG finance or other digital finance aspects.
Interesting. What else?
Digitalization. Luxembourg's already got electronic registers like the LBR and RBE. Electronic signatures are valid even for notarial deeds now. This helps diligence, but maybe brings new questions too. Apparently, the CSSF is even looking at using AI in its supervision work, which could change interactions down the line.
AI in supervision. Wow, okay.
And finally, those ongoing discussions about reform of contract law in the civil code. Influenced by neighbors like France and Belgium, if they formally introduce something like improvision the hardship doctrine that would allow courts more power to adjust contracts, that would definitely impact how enforceability opinions are drafted and qualified.
So looking at the big picture, what's the main takeaway from these trends?
Well, as the source suggests, that MICAR development feels like a really profound shift, making law firms quasi-regulatory gatekeepers that significantly up their responsibility. It maybe suggests a future where regulators increasingly lean on law firms for expert validation in these super complex, fast-moving areas.
So to quickly summarize what we've covered based on the source, the Luxembourg legal opinion is, well, both powerful and essential in cross-border finance.
Right. Its strength comes from that unique mix. International practice meets robust local laws, especially the 1915 company law, and that crucial 2005 financial collateral law.
It's a complex process, definitely involves careful work and negotiation, but the end result provides invaluable certainty. It really underpins Luxembourg's role in these big international deals.
And the landscape is clearly not static. It's evolving, with regulations like MICAR pushing opinions into new territory, playing new roles.
We've seen how this practice is grounded in specific laws and traditions, but it's also adapting incredibly quickly to new challenges like crypto assets and changing regulatory needs.
Yeah, and that leads to a really interesting thought. As law firms are increasingly asked, or even required, to act almost like regulatory checkpoints through these mandatory opinions like the one for MICAR, how might that fundamentally change the dynamics? The relationship between lawyers, their clients, and the state itself in the financial world of the future.
That is something to mull over, a potential shift in roles and responsibilities.
Definitely food for thought.
This podcast contains content generated or significantly edited using artificial intelligence tools. All information is provided for general informational purposes only and reflects knowledge available at the time of publication. It does not constitute financial, investment, or legal advice. We recommend the listeners verify the information independently and consult with qualified professionals for personalized advice. Hit that like and subscribe button,
It was the Luxembourg Fundcast for you today.